Hi, my name is Carl Pearson, and this is my video number 132 entitled Movie 99 Homes, What the Florida Homeowners Could Have Done to Save Their Homes from Foreclosure. 99 Homes is a movie starring Michael, Shannon, and Andrew Garfield, and it's a must-see film. It's scripted, full-length, although it has only limited distribution. It is a feature film, and it dramatizes some of the many evils and pitfalls for homeowners involved in the home foreclosure process throughout the nation. The story is about Florida, a state which requires foreclosures to take place after the filing of a summons and a complaint and the grant of a judgment of foreclosure and sale and writ of possession. Only 22 states in the U.S. are judicial foreclosure states. The rest are non-judicial, with a foreclosure taking place without the formality of a foreclosure lawsuit. My background is important for you to know. I have spent most of my life as an attorney prior to 2008 enforcing the nation's antitrust laws for small businesses and consumers. And since 2008, I have spent most of my time defending foreclosure actions. I have more than 50 years of litigation experience. I give this film a hearty double thumbs up. With this video review, I want to add to the story so that persons interested in foreclosures can obtain additional information needed after viewing the film and thereby obtain a more accurate, timely account of what is happening in Florida and elsewhere in the U.S. at this time, which is on Christmas Day, December 25, 2015. The film works well in showing various foreclosure evils, but viewers need to know that to fight a judicial foreclosure, the homeowner has to retain a competent foreclosure defense attorney and not a volunteer pro bono attorney or attorney friend practicing in a different legal field. If nothing else, you need to know that the homeowner needs a skilled attorney as well as a skilled loan processor to have the best chance in saving the home from foreclosure in any of the 50 states. These two professionals should be retained immediately after the homeowner is served with a copy of the summons and complaint in a judicial foreclosure state, if not before. Time works against homeowners because at some point the amount of unpaid monthly payments takes the homeowner beyond the point where a loan modification offer can be made by the bank or servicer or note owner. There are perhaps 100 different issues to prevent or delay foreclosures that a competent foreclosure defense attorney has to consider, trying to find a way to defend against a judicial foreclosure. It may take only one failure by the bank's attorney to provide the needed defense, but every possible issue should be considered for best results. It takes years of defense experience to learn about these issues, and more issues are being added from time to time. A homeowner represented by someone who doesn't know what these issues are is not being adequately represented, regardless of the cost. The attorney cannot learn what he or she needs to know in defending a single foreclosure. Homeowners should be aware that the banks and real estate industries combined have more than 2 million people participating in taking your home away from you. There are 1.5 million bank employees, 394,400 real estate agents, and various other real estate brokerage employees, bringing the number up to 2 million or so. They have developed a workable system for taking back the mortgage property supported by laws and courts, and you will need all the help you can get from an experienced foreclosure defense attorney and loan processor. Do whatever you need to do to retain them. Sell whatever you need to sell to raise the money, because it will be the best money you've ever spent. And that will give you the best chance of saving your property. Trying to hold off the expense until later or the last minute will usually cause you to lose the property through default and mistake, which usually cannot be cured after the default or mistake has occurred. Another quite basic problem is whether the homeowner has sufficient income to make monthly payments on a modified loan. If not, the homeowner needs to get these two persons involved even months before a lawsuit is commenced. When you first stop making mortgage payments to see what can be done to increase income, decrease expenses, and put you in a financial position to qualify for a loan modification agreement. A vigorous defense of the foreclosure action may enable you to get sufficient time to put your financial affairs in the needed order to save your home. Bankruptcy is also something that should be considered. In the film, the evictions might have been avoided temporarily or longer through bankruptcy filing and the need of a bankruptcy attorney. In my YouTube description of my video, I include 2 website links of interest. The first is to the specific Florida statute governing foreclosures, and the second is to a title insurance company's description of the entire foreclosure and eviction process in Florida. They are worth looking at. Now here's my first comment about the film. The scripted foreclosure proceeding was not properly defended, and if it had been defended properly in the script with motions, opposition, reply papers, and judgment answers and the like, the critical turn of events probably would not have occurred as they did. The screenwriters were taking necessary liberty with details, but it is these details that defense attorneys use to save homes threatened with foreclosure, even though the note is in admitted default. The writers may have been alluding to the infamous manual of a major bank explaining to its employees and the bank's numerous attorneys how to obtain a foreclosure in spite of the state law requirements. Homeowners did not learn from the film that retaining a competent foreclosure defense attorney to defend the foreclosure action is the best way to save the threatened home, even if the homeowner knows that he or she hasn't made the monthly payments required by the note and mortgage. A competent foreclosure defense attorney can make a big difference, but it would have made the film less compelling. I hope that this video helps homeowners facing foreclosure to defend their home properly and timely. My second comment is that there is something which probably could be done for the homeowners even though they presumably owe the money to the note owner. Homeowners, attorneys, legislators, and judges throughout the 50 states have not yet discussed the antitrust issues as of today, Christmas Day, which is somewhat difficult to accept that it took me 6 years until January 2014 to become aware of the antitrust violations. And I'm a highly experienced antitrust attorney. These violations, if raised as defenses in the hypothetical 99 homes Florida foreclosure actions, probably could have resulted in the grant of loan modification agreements to enable most of the 99 families to save their homes. The owners of the 99 notes would probably have settled the foreclosure lawsuits with the grant of an affordable loan modification agreement to be able to stop the antitrust violations from being pursued as a defense and possible counterclaims in the foreclosure actions brought in Florida. Federal antitrust law provides a 4-year statute of limitations from the date of the violation, but when you have co-conspirators, the statute of limitations starts running only when a co-conspirator announces that he or she has left the conspiracy. This means that the statute is not run even as to the violations starting as early as 2008. No bank or servicer has so far announced that it is leaving the conspiracy. Florida antitrust law is basically the same as federal antitrust law. Here are the antitrust violations. The major banks and their loan services are not permitting the homeowners themselves or their friends, associates, or families to purchase the home in a short sale through an industry-wide agreement requiring an arm's length transaction. If every bank did this individually without agreement with the others, there would probably be no antitrust violation. But the servicer banks are enforcing this requirement on the defaulted notes for all of the bank note owners they service, making this a per se violation as a horizontal conspiracy to blacklist or boycott the homeowner directly or indirectly from buying the home through a short sale, even though the homeowner already residing in the property is the one person who is more apt to pay more for the home than anyone else. This violation flows into other areas such as refusal to offer all loan mitigation possibilities during court-required mediation procedures such as under the Civil Practice Law and Rules 3408F in New York, calling for conferencing where both sides are to be in good faith during the conferencing. But the agreement prohibits this good faith from taking place. It includes an unwillingness to offer or sell the homeowner the defaulted note when offering the defaulted note and mortgage to persons similar to the fictional Rick Carver or vulture fund purchasers of defaulted notes. Remember, Rick Carver said that the note was being sold 1 million times. My third comment. In December 2013, the Justice Department and 49 state attorneys general entered into a national mortgage settlement agreement. The three servicer groups are 1. National Mortgage, 2. Ocwen, and 3. Sun. National Mortgage serviced loans for Ally, meaning GMAC, Bank of America, Citi, JP Morgan Chase, and Wells Fargo. Ocwen services loans for American Home Mortgage Servicing, Homeward Residential Holdings, Litton, and Ocwen itself. National Sun Trust Settlement was for Sun Trust. The other banks, of which there are almost 7,000 commercial and thousands of savings and loans, were not involved, so that the settlement was not binding on them. There were minor payouts to homeowners who lost their homes, and there were agreements to provide affordable loan modifications, sometimes with principal reductions. But these funds have been used up, and the applications for loan modification agreements today to these major servicers and banks are being denied far more frequently now than ever before, mainly because the banks and servicers don't want to pay the cost themselves, meaning they don't want their investors to have to suffer any losses in order to accommodate homeowners. The script made it clear that homeowners can't expect much from Congress. At page 57, the script has Rick Carver stating, "Up until 3 years ago, I used to be putting people into homes and speculating on properties. Ask the banks why they gave them an adjustable rate mortgage. Ask the government why they lifted all regulations and turned a blind eye. America doesn't bail out the losers. America was built by bailing out the winners, by rigging a nation of the winners, by the winners, for the winners." This leads to the important conclusion that in order to have a better chance today to obtain a loan modification agreement, a homeowner should be asserting his defenses and claims in court to encourage the servicer and bank and their investors to give a loan modification agreement out of their own pockets to be able to bring the foreclosure litigation to an end. The film has no time to make this point, even if they were aware of the issue, and as a result, viewers might not understand how to fight the foreclosure forces described in the film. In Florida and the other 21 judicial foreclosure states, the homeowner should retain a competent foreclosure defense attorney to prepare, serve, and file a timely answer with affirmative defenses and perhaps counterclaims to the foreclosure complaint. And in the other 28 states, the homeowner should be thinking about commencing a quiet title action, or if a foreclosure and sale has already occurred, a wrongful foreclosure action. In conclusion, 99 Homes, as far as I'm concerned, tells a story almost as significant as Rachel Carson's 1962 book, Silent Spring, about pesticide poisoning of the environment, and Upton Sinclair's 1906 novel, The Jungle, about Chicago's livestock slaughterhouses. The needed changes cannot be expected because the legislators can't afford to go after their financial supporters. This makes foreclosure defense the only practical way to defend one's home, coupled in some cases with Chapter 7 or Chapter 13 bankruptcy proceedings, which is a whole nother story which threatened homeowners need to learn. Even though my office is in New York, I can help homeowners in other states by working with our local attorney. I believe this is the best way to defend a foreclosure action when you are unable to find an experienced foreclosure defense attorney in or near your county. If you want to discuss your matter, please give me a call at 212-307-4444. That's 212-307-4444.